This is Dr. David Shine, and welcome to Business Law 101. Now, one of the more controversial issues, and this is something big companies like Halliburton here in Houston, the reported case regarding mandatory arbitration is the Waffle House, the chain of waffle breakfast places, Waffle House, required its employees to sign a mandatory arbitration agreement. And what it just says is it just says when you work here, if you have a dispute regarding your employment, you agree to either mediate it or to arbitrate it. So that's a relatively common technique. And I'm actually, the case that I just mentioned where I'm mediating and arbitrating is actually a mandatory employee arbitration case. That former employee is under one of those agreements. A lot of companies employment cases can be very troublesome and can be very expensive for the employer. So starting, I guess, about 20 years ago, a number of companies began to adopt mandatory dispute resolution clauses. So when you go to work there, they give you a contract that says, if I have a problem with you related to my employment, I agree that I will go to mediation, and if that doesn't work, I'll go to arbitration, but I'm not going to go to court. And so that's called mandatory arbitration, but it starts with your signing a written agreement when you start work there that you're willing to do that. And like I said, I don't know how many big companies in Houston have it, but I do know that Halliburton, which is a very big company based here in Houston, requires employees to sign dispute resolution clauses that they'll go to either mediation and or arbitration.